Hello everyone, I'm Aaron Jacobs and I'm a partner with Butler Subrogation Recovery Team in our Tampa office. Thank you so much for joining me today for Subro in Seconds. It's wintertime again, and many of the areas of the country are experiencing sub-freezing temperatures. In fact, annually, winter storms and conditions account for about $1.5 billion in first-party insurance claims. Many of those claims involve pipe freeze bursts. In a typical case, the subrogating carrier will investigate by hiring an engineer to determine the root cause of the burst or the failure. However, that may not be the most difficult aspect of the case. Oftentimes, the more challenging aspect is identifying the potentially liable parties. The Eastern District of Pennsylvania tackled this issue recently in an opinion that states who's responsible for the damages caused by a pipe burst. In that case, a subrogating property insurer asserted a claim against a sprinkler installer for damages caused when a pipe burst at a rehabilitation facility, causing over $300,000 in damages. The sprinkler installer, in turn, sued the facility's general contractor, the maintenance contractor, and the inspection contractor. The subrogating plaintiff asserted direct claims against the third-party defendants as well. In analyzing the various claims and defenses at issue in the case, the court had to take a very careful look at the contracts between the facility's general contractor and the various subcontractor defendants. There were a number of critical legal issues and doctrines that the court had to consider when evaluating each one of these claims and defenses, such as third-party beneficiary, contractual indemnity, privity of contract, as well as the gist of the action doctrine, which essentially means that you can't prosecute in claims in tort arising out of a breach of contract, something akin to the economic loss rule. The most important part of this case is it highlights the various difficulties and complexities that may be involved in what may seem like a typical standard pipe burst case. When evaluating these cases, it's critical that you get all the underlying contract documents between any of the general contractors, subcontractors, inspection contractors, maintenance contractors, and carefully review them for things like waivers of subrogation, contractual bars to subrogated claims, or other exculpatory clauses. This case is important because it highlights all the various parties that may be involved in a pipe burst or other construction defect claim. When evaluating a pipe burst claim, it's important that you get all the construction documents associated with the installation of the pipe system and any records and documents associated with the maintenance and inspection of the piping. For a more complete discussion on this case and other case updates and blogs, please visit our website, www.butler.legal. Also, please be sure to subscribe to Butler's subrogation podcast, Subro Sense, and please stay tuned for the next episode of Subro in Seconds. On behalf of the entire subrogation recovery team at Butler, I'm Aaron Jacobs. Until next time.